under section 11 within bracket 6 of the Arbitration Conciliation Act, whether the petitioner is paid for appointment of arbitrator on account of arbitration clause which exists in the agreement dated. Where is that agreement date?
Lordship, you will find the agreement on page 39, 27 Jan 2017.
24/1/2017.
24 Jan, Lordship. 24 Jan.
Issue notice of motion returnable in 4 weeks. Requisite extra copy of the writ petition is served on the standing counsel for respondent number 2 in course of the day. Next steps within 2 days. Returnable in steps within 2 days for service of notice by the on the respondent number 1 by registered post with AD. In addition, the petitioner shall serve notice on the. Actually, this is Calcutta. Okay, registered post with AD list after 4 weeks.
Obliged.
May I please?
In
So in
this
this
matter,
case,
my
my
lord, I have to obtain instruction regarding the case, my lord, but extra copies were not found, so we could
We
not
did
send.
not order giving an extra copy
my
because
lord. But still, it is not there, my lord. I may be allowed 2 weeks time, my lord, for having instruction. No communication has made, I found. My lord.
this is not looking good.
Yes, my lord,
We have to fix it next week because I have not issued a notice of motion.
my lord,
I don't intend to keep the notice of what you call motion matter for long.
my lord.
Wednesday, you get it by Wednesday, you give a extra copy.
Yes, well, I will do that.
So dig over and the counsel for the petition shall furnish the extra copy of the petition to the Ms. M. Burma Dana Government Advocate to enable her to obtain instructions as to whether any
On last order, my lord, regarding threatening part, FCI council has already submitted that no such threatening was happened, my lord. But so far as our part is concerned, we have to take instruction as court direction is there. Whether the laborers are threatened or not.
to obtain instructions, only that, to obtain instructions. Okay. The instructions will only be if they have
Yes,
caused
ma'am.
any complaint or not, only that much.
Only that.
Not
Replayable.
List on word 28.
28 all extra.
Hi,
That's it. Lordship. But
Yes.
petitioner is the legal heir of late Muninder Devnath Nair. But private respondents needed and their names in the land record of the petitioner by showing themselves that they are the
Where is
son
your
of
where is your petition for this deletion of mutation? Where is that?
my lord, annexure, my lord.
Give the page number.
Annexure 5, page 27 to 29, ma'am. The representation. Filed before the deputy commissioner, Morigaon, madam. Private respondents shown that their father, son of late Munindra, but their father
See,
only the.
I don't understand this, Islam.
Madam.
You want a deletion of the mutation and you file a representation.
No, the deletion of the names of the private.
That's what I am saying, deletion of mutation.
Right.
And then you are not filing an application, you just serve a representation. Does under the Assam Land and Revenue Regulation, does the deputy commissioner or the estate and settlement officer work on a representation?
And regarding forgery, my lord, that was complaint has been filed before the.
And then you continue going on, we'll give you liberty. Every year you can give at least 100 representations.
My lord.
Nothing is going to happen.
My lord, deputy commissioner have the right, my lord, to do the correct.
No, if you don't understand, I can't put anything in your head. If you don't want to understand, I can't give anything in your head.
Madam, sorry.
Under Assam Land and Revenue Regulation, you have certain years of experience. Have you ever seen in a mutation case the ADC working on the basis of representation? Have you seen that in your experience?
My lord, on the application মানে KRCM
जो कर बोलेंगे।
on representation it was
Okay.
can correct.
Mr. B. Islam, Learned Counsel for the petitioner, was informed that under the land and revenue regulation, there is no provision for the land settlement authorities, including the deputy commissioner, to work on a representation for cancellation of mutation. However, he is adamant that the authorities should work on a representation. So accordingly, the court does not find any merit in the writ petition, and therefore this writ petition stands dismissed with liberty to the petitioner to move the competent authority in an appropriate manner as required by law.
Six.
Yes. Addition notice. Addition notice in the matter. Heard, Mr. P. K. Kalikar and Senior Counsel, assisted by Mr. K. R. Barwar and Counsel for the petitioner, and Ms. M. Burman and Government Advocate appearing for
2 and 3. my
the
lord.
respondent numbers 2 and 3. Next para. By filing this writ petition in the Article 226 of the Constitution of India, the petitioner has assailed the judgment and order dated 23/9/2022, passed by the Assam Board of Revenue in 94 RA within bracket capital BIS bracket close oblique 2018, by which the appeal filed by the petitioners was rejected. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned Government Advocate for respondent numbers 2 and 3. Next, the petitioner shall take steps. Petitioners shall take steps within 2 days for service of notice on respondent number 1 and 4 to 9 by registered post with AD. The learned instructing counsel is at liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. There's nothing to stay. We are able to dismiss. Your prayer is
Already.
your prayer is for interim prayer is for
Yes.
stay.
7.
Yes,
This is non-payment of the higher.
non-payment of hire charges,
Notice.
vehicle hire charges, non-payment. Non-payment of vehicle hire charges. Mr. L. Mohan for the petitioner, Ms. M. Burman, Government Advocate appearing for respondent numbers 1, 2, 3, 4, 5.
2 is BTC, my lord.
Oh, no, 1, 3. Sorry,
1,
1,
3.
3, 4, 5,
4, 5,
6, 8.
6, 7, 8.
No, it's not 7. 7 will be BT. No, BT, police is with you.
Police, I'm
Ah, then 7, 7, 8,
7, 8,
9, 10.
9 and 10.
Mr. S. R. Rahul, stand person for BTC. Takes notice on behalf of respondent numbers 2 and 8. Sorry, no, 2 and 11. 2 and 11.
Passport officer, phone number. Yes.
I tell this. Extra copies and goes on the pendency of the writ petition shall not be allowed for the respondent authorities to examine the claim of the petitioner and to release payment if found due. Petitioners have produced a certified copy of this order before whom?
My lord, it is the IGP admin,
DGP administration.
DGP admin.
Administration, respondent number,
8, my lord, it's additional
8.
Inspector General of Police admin.
just additional inspector general of police. Administration,
Administration.
which is responding rate. To
6
bring
and
the order
8.
to the notice of the said authority. Yes. Next item.
8.
Mrs. Barua, we can't entertain this repetition.
Why, my lord?
You see, your prayer is that there is a judgment of this court
Yes.
dated 15/5/2023 in WPC 520 and
Yes.
WPC 728. And your prayer in this writ petition is to review that order. In writ petition, I can't review another order of this court.
I am testing order of the Supreme Court as well as the.
No, review is a review
Yeah,
jurisdiction.
because
In a writ,
the High Court has a plenary power. my
you see,
lord.
Mrs.
Under
Barua,
High Court, Article
Mrs.
2.
Barua, there is a Supreme Court judgment of 9-judge bench. It says a writ cannot be issued on a court. I cannot issue writ to my own court. Can I do it?
Not read, my lord.
This is the
I
writ
have
petition.
come for review of the
Review,
order. my lord.
no, review, file a review application. How can I issue a writ against the High Court?
I may be wrong, my lord, I may be permitted to. wait for them. Oh, Leela. The first thing. Huh? No, it will release. It will go to the. How could you do this? Para 5 and 6 our I put my development. At this stage, it will be helpful to refer to the decision of Supreme Court in the and so on. So, Secretary Supreme Court 1909. In that case, on the petition filed for cancellation of the order of allotment passed by Director Rehabilitation in favor of some persons, High Court cancelled the order of allotment, although these persons in whose favor the allotment was made were not party in the writ petition. Subsequently, allottees who were not party to the writ petition made petition undersigned to the for impeding them as party to the writ petition and rehearing the whole matter. The High Court allowed the writ petition. In that case, the Supreme Court has held that the second writ petition filed by the allottees was maintainable and the High Court has not acted without any jurisdiction in reviewing its previous order at the instance of the person who were not party in the previous writ proceeding on the ground that their interests were sought to be affected by the decision of the High Court. It has also been held that there is nothing in Article 26 of the Constitution India to preclude the High Court from exercising the power of review which inheres in every court of plenary jurisdiction to prevent miscarriage of justice and culpable errors committed by it. In entertaining the second writ petition, the High Court thereby did what the principle of natural justice required it to do. Since the above decision of the Supreme
I'll
Court
tell you,
after-
Mrs. Barwa, you see, this is a judgment which is reported in 1963 AR
Yes,
1909, correct?
Yes.
This is by a constitution bench. Now, after this, you just note it down. AR 67, Supreme Court 1. Correct. This is the case of Naresh Sridhar Mirzakar, where the Supreme Court 9-judge bench has said a writ would not lie against a court. I'll show you that passage.
Actually, my lord, this is not a writ against the court, my lord.
You see,
In this, by this filing the second.
No, it's okay, but you'll have to do it.
petition,
I can't help it. You have to come in review jurisdiction. I'm just showing you from the head note, Mrs. Barwa, I'm just showing
Actually,
you
my
from,
lord, in this case, the government should have come for review.
no, it's
so the-
okay, but I'm just showing you this from the head note. Because this I've read long back, I can't identify the paragraphs immediately.
But
So I'm
then
just
let-
showing you from the head note.
Then let it come on
Just-
Friday, my lord, I'll go to.
Just look at the head note. I'm showing it to you. I forgot the paragraphs. It is either 58 or 52. I forgot. So you see, writ does not lie against the court. That is the one of the observations. Paragraphs immediately I forgot. I won't remember the paragraphs immediately. You take instructions.
I'll go to, I'll take
Yeah.
it. Come on Friday.
Okay. Mrs. U. Barwal and Senior Counsel, assisted by Mr. S. Count, Counsel for the petitioner, places reliance on the case of Shivdev Singh, SHIVDEV Singh and others, versus State of Punjab and others, decided by a Constitution bench of the Supreme Court of India and reported in AR 1963-1909 to contend that order of the High Court under 226 of the Constitution of India can be reviewed by another petition under Article 226 of the Constitution of India. Full stop. It would be appropriate to refer to the decision, a subsequent decision of a nine-judge bench of the Supreme Court of India in the case of Naresh, N-A-R-E-S-H, Sridhar, S-H-R-I-D-H-A-L, Mirajkar, M-I-R-A-J-K-A-R, versus State of Maharashtra and others, where it has been held that no certiorari can be issued against order of a competent court having jurisdiction. First, next one. In view of the learned Senior Counsel for the petitioner, is for some time to go through the said decision and address the court. Next, the court is privacy of the view that the previous order of this court can still be reviewed by way of an appropriate application for review. First of this said aspect shall also be examined by the learned Senior Counsel for the petitioner. Next, Mr. D. Sharma, learned Additional Senior Government Advocate, and Mr. K.P. Pathak, learned Standing Counsel for
It's one number 3588.
3-5
For the forest department.
for the
3589.
for the forest department are present. You also be prepared on that day. Yes. A list on Friday.
Problem.
Your citations, I'm returning.
9.
Yes, excise.
Yes,
Okay.
if a notice may be issued, similar matter already been notice has been issued.
P.V. Barwa, Counsel for the petitioner. And Mr.
Kindly record the name of N. Goswami, excise.
P.N. Goswami.
N. Goswami.
N. Goswami, Standing Counsel for the Excise Department. And Ms. N. Rohan, Government Advocate appearing for the respondents. Next, Paran. Issue notice motion returnable in 4 weeks. Requisite extra copies in course of the day. Next, Paran. The pendency of the reparation shall not be a bar for the competent respondent authorities to examine the claim of the petitioner for IMFL on license.
The tennis.
Right? Can you say
Next.
that is also IMFL on?
Yeah, I'm. Yeah, this will see. This matter relating to the facilities of the judiciary in the district of Puraja matter.
Pardon me?
This matter is relating to the QCDC in the BTC area in the district of Kokrajhar, my lord. So,
But this is not a, what you call. You don't have a permanent right. Come to page 25.
my lord,
Tenure of VCDC, please read that.
there is, my lord, 5 years, my lord.
No, please read it. When I'm asking you to read it, please read it.
The tenure of the VCT is around 4 terminus of the BTC Legislative Assembly, constituency that is 5 years from the date of appointment of officer of first meeting or dissolved earlier by the BTC. However,
bas.
tenure of the present nominee of the VCTC is 6 months, which may be extended.
So 5 years got dissolved earlier. And BTC has dissolved it. You can't do anything about it. It's a doctrine of pleasure which applies.
My lord, they have enough for my lord. My humble submission is that the new VCDC is complying with the dead person, my lord, who has died much earlier than this input notification. He has died in 2021, and this notification has been issued in 2023, my lord.
Yes.
So it
You
is,
see, if a dead man is made the VDP member,
my lord.
the village will be all right. Everybody will be afraid of him.
Yeah.
Is it not? We are all afraid of ghosts.
My lord, it is
In Old English, we call it Ghol, G-O-U-L or G-H-O-U-L. Old English. Yes, how a dead man you are appointing?
I think that is totally a different issue.
No, but he can challenge it. Every public has a right, notwithstanding that he is a erstwhile member.
For that, I need instruction, my lord.
If you are appointing a dead man, then definitely everybody will be amused.
That
Unless,
allegation needs to be,
unless you can convince us to believe in ghosts.
my lord. We'll check with the allegation.
Yes,
My lord, and the
Most-
inquiry is directed, my lord.
most serious person here is Mr. Deka sitting behind. If he is convinced, he will permit you to be continued. Okay, you made out a case. Yeah, Mr. D.P. Mandal,
My lord.
Mr. D.P. Mandal and counsel for the petitioner. And Miss M, Miss S.
And Bora.
And Bora, standing counsel for respondent number 1. Acha, 1 to 4. No, 1,
I'm one.
only 1. Who will be appearing for 3, Panchayat? Mr. Datta? Or you will be appearing?
But I can represent. Yeah,
The number 3,
yes, sir.
you can appear?
Yes.
Okay. Yeah, and Mr. S.R. Ravan and standing counsel for BTC and PNRD. Appearing for respondent numbers 2, 3,
And 5,
2, 3, and 5. Ms. M. Badman and the government advocate appearing for respondent number 4. Next paragraph. The termination of the petitioner as a member of VCDC within bracket Village Council Development Committee. Of which village? Which village?
My lord, it is a Mohamaya VCTC, my lord.
Okay. Of Mahamaya, MAHAMAYA. Under number 1. Parbat Jhora, PARBAT JHORA within bracket ST, bracket post constituency. Under Mahamaya Development Block. No, you are the chairman.
My lord.
The commission of the petitioner is chairman of this section, so is assailed in the present writ petition. And it is submitted that the new VCDC that has been constituted. Where is that? Where is the new constitution order?
Page 19, annexure B, my lord.
19.
Page 19, annexure B.
By notification dated 13/2/2023, is assailed on the ground that the newly appointed who has been appointed, serial number, is a dead person, who is the dead person?
My lord, in CL number 21, my lord, Jagan Singh.
That one of the member at serial number 21 of the said notification, namely Jogan, Jogan Singh, Sing, was already dead on the date of the appointment. Next paragraph, issue notice of motion returnable in notice of motion including notice on the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the petition be served on the running state and departmental council in course of the day. We just say notice including notice on the prayer for interim relief. List after 4 weeks. Next paragraph, that is okay. I'm issuing a notice on this.
My lord, oblige.
Well. Yes, Mr. Datta.
See, I am coming against disconnection of electric supply to my shop, lordship.
We'll have to issue notice. And in the
Perhaps
meantime,
there is an alternative prayer made in your lordship that he should be given a fresh connection. So there is a document available on record which says that the electricity supply to the shop in question has been permanently disconnected. So that connection cannot be revived. But if he makes a fresh connection, your lordship, we can definitely consider it as per rules.
okay,
So it can be allowed also, your lordship, in those terms.
okay.
As per lordship, electricity, like, even if it is disconnected, they have to adjust the amount, lordship. That has not been done. And the claim of the respondent is that my connection was disconnected. In fact, although it is disconnected on lordship 3323, but their claim is that it is disconnected in the year of 2018.
No, whatever if you see, we are not going into the dispute.
Lordship.
They are permitting you to apply afresh and
Yes.
get it.
Yes.
Correct. So you get it and whatever bills have been generated for that period unpaid, that you have to clear.
According to them, after 2018, they have not generated any bill in
It's
spite
okay.
of my
If there is any,
Yes.
that you have to clear.
and the security amount in respect of earlier.
It will be twice the amount of normal. It's twice.
This is, he wants a fresh connection, a normal
It's okay.
connection. So
No. If he's not the owner,
if he's not the owner, then
you
yes.
take twice the
Yes, if he's
amount
not
of
the
security.
Yes, lordship. The earlier amount has to be adjusted, lordship, because it is pending before that.
But it can be disposed of as per rules, your lordship.
For Mr. U. Datta, I'm the counsel for the petitioner, and Mr. K. P. Patak, and standing also for the
APDC.
APDCL, appearing for
For-
respondent numbers
2, 3, 4, 5, 6.
2 to 6. And Ms. M. Burman and a government advocate appearing for respondent number 1. Next paragraph. My filing this repetition under Article 226 of the Constitution of India. The petitioner is seeking a direction upon the respondent authorities. The respondent APDCL authorities for restoration of electricity supply. The electricity energy supply to his shop over DHETI number 195 within bracket close at Moira Bari, MOIRABRI. What is bi-weekly? This is first time I'm hearing.
In their week twice, lordship.
No, that will be bi, it can't be die.
They have used the word the die weekly, lordship. That is right.
It can't be, just show me that. It's incorrect English. Where is that?
Bi-weekly.
It can't be die. Even if they write it wrongly, they can't write it wrong.
In fact, it should be
Twice in a 1 week.
It is Moirabari Divo Haptahik. Huh?
the twice a week.
That is Bo, but page 51.
Yes, 21. 24.
Perhaps it means that the market will sit once every 2 weeks, you know.
So it is bi-weekly. Bi-weekly, it can't be die. It
Yes,
is
it cannot be die.
the bi-weekly market. Which has been disconnected. Next paragraph. The learned counsel for the Prashna projects that the electricity supply was disconnected on 27/3/2023. Which is disputed by the learned standing counsel for the APDCL, because as per his instructions, the disconnection of electricity energy supply was made permanent disconnection
On 22/6/2018.
on 22/6/2018. Full stop. Next paragraph. In view of the consideration that electricity energy supply is an essential service, comma, the court is of the considered opinion that as essential service, restoration of essential service is involved in this repetition, comma, issuance of notice on the respondents, including respondent number, private respondent number
7.
7 will be dispensed with in view of the nature of order proposed to be passed. Next paragraph. Without entering into the dispute as to the date on which electricity energy supply was disconnected, comma, the court is inclined to provide that in the event as per the APDCL records, comma, the electricity energy supply has been permanently disconnected, comma, the petitioner would be at liberty to apply for a fresh connection by following all the codal formalities as may be required to obtain such permanent connection, fresh connection. First of all, it is also provided that in the event any unpaid electricity energy charges are to be paid for earlier for supply which was made previously as consumer number 1150000483335, comma, the petitioner would have to liquidate the previous dues, previous of the area dues with applicable surcharge. So the petitioner shall also have to deposit the security, fresh security deposit. And in this regard, if any adjustment is required to be made by the APDCL authorities for the previous connection, they said adjustment shall also be done by the APDCL. Next paragraph. It is also provided that if there is any interstate dispute between the petitioner and the private respondent number 7, they would be entitled to go to the competent court having jurisdiction to settle their interstate dispute without involving the APDCL in such litigation. Next one, accordingly, this writ petition stands disposed of with liberty to the petitioner to apply for a fresh connection in terms as indicated above. Next one, as this order has been passed without issuance of notice on the respondents, the respondents are given liberty to apply before this court for modification of the order if so advised. Next one, petition disposed of.
So in fact, title suit is pending and status quo order is there.
No, whatever way, but don't
Correct.
involve the APDCL number 1.
Yes.
Since I'm passing ex parte orders without giving them an
No, they
opportunity
are
of
not.
hearing,
part- they are not.
they can appear before this court and ask for modification.
13,
My lord. The chief knows that the deputy commissioner is the empowered officer under the law to cause all land acquisition. But in this case, my lord, the deputy commissioner, while acquiring land for construction of its own office at Rupnagar at Guwahati, my lord, had violated all provisions of law. Lordship would see Annexure 3, page 35, where the land was requisitioned, my lord.
Yes.
This is done under the Assam Act of 1964.
Acquisition notification has not come.
No, my lord, till date, the requisition came and they took over possession in June 2022, my lord.
Okay.
Till 1 year has gone by, my lord, till date, no requisition compensation or acquisition compensation has been processed.
No,
my
for
lord.
requisition, you'll only get a rent,
Right, my lord.
but yes, acquisition, yes.
Yes,
Had Mr. B. Patak Lamal, counsel for the petitioner. And Mr. M. Bhavan and the government advocate appearing for respondent numbers 2 and 3, and Ms. G. Hazarika, standing counsel for the Land Revenue and Disaster Management Department for respondent number 1. Next para. The case of the petitioner is that the land of the petitioner was requisitioned by order under Form B dated 24/5/2022 for construction of the office of Deputy Commissioner, Kamrup Metro Guwahati. So it is submitted that without permission from the petitioner, a permanent construction has been set up on the land without formally acquiring the land. And accordingly, by filing this petition in Article 226 of the Constitution of India, the petitioner is seeking a direction for has prayed for setting aside and quashing of the order under Form B and C dated 24/5/2022, issued under Section 3 within bracket 1 of the Assam Land within bracket Requisition and Acquisition bracket close Act 1964. For a direction to de-requisition the land under Section 8 of the said Act with an alternative pair to direct the respondent authorities to acquire the land by giving adequate and fair compensation to the petitioner, as well as to pay land requisition compensation from June 2022 till date. Next, issue notice of motion to turn over within 4 weeks. Requisite extra copies of the writ petition be served on the learned state and departmental council in the course of the day. Next paragraph. As the petitioner has been deprived of enjoyment of his own land, comma, the comma, in the event the respondents do not file their affidavit in opposition within the time allowed, comma, the Deputy Commissioner, Kamrup Metro, within bracket respondent number 2, shall sorry, do an additional Deputy Commissioner within bracket LA branch bracket to Kamrup Metro shall ensure production of records through their learned government advocate on the next date of listing. List after 4 weeks. Next paragraph, the petitioner shall, the learned government advocate shall, government advocate and the learned departmental council shall transmit or order this court to the competent authorities. Moreover, the petitioner shall also produce a certified copy of this order for the Deputy Commissioner, Kamrup Metro, to bring the order to the notice of the said authority.
But as far as the directing instruction, I have been instructed to appear for respondent for BPC.
Additional notice here. And what about this testing of retention samples? Why-
Kindly see this reply, my lord. In the page 31, my lord, he opened the sealed, my lord, box, my lord. In third paragraph, my lord. Page 31, my lord.
Page 31.
Yes, my lord. In middle part of third paragraph, my lord, I beg to state that on 23.
Just a minute. Third paragraph.
Yes, my lord. Is start from we, my lord. Then my lord, in middle
Ah,
portion.
ah, ah.
I beg to say on 23, we retested the density of the one or retained sample of the MS. My lord. It was just sealed, my lord. As per the annexer 1, my lord.
Just a minute. Where is the show cause notice?
My lord,
How many sealed containers? were
page
there?
20, my lord.
Page?
20, my lord. Annexer 1, my lord. In last portion, my lord. These are the my lord, seal, my lord.
One set of sample.
Sample 1 set of RO sample 2. my
Then
lord.
we can't do anything. Your petition has to be dismissed then. Nothing can be done.
But
One
yes,
sample was sealed by them. And you yourself broke the seal and did the retesting. So therefore, there's no sample left.
No, your lordship, two samples were there, your lordship. Out of the 2 sample on bona fide belief, after the test laboratory report has come, he has opened one on bona fide belief that opened
No,
one.
that bona fide belief what you call would be adverse to you.
Yes, your
can't-
lordship, he has informed to the authority, and on his application, they have initially agreed upon to retest the retaining sample. But later on, he was offered to provide the location laboratory of his choice, and he has given his choice by his letter, and thereafter they have denied, your lordship.
No, definitely, sealing is not done for anything. You ask somebody, he'll say yes.
But your lordship, in nowhere it was mentioned that both the samples were necessary for the test. Your lordship. In fact, it was said that in the
No, no, you
absence
see,
of the,
the seeding is not done for just for fun.
because it was set up only last 2 years. Huge investments were there, your lordship. So a fair chance may be given. That is the humble request, your lordship.
It can't be.
And
It can't be given.
after the rejection, he has again filed one application for reconsideration of retest.
It can't be. You see, what you have done in this page 20,
Yeah.
there's a box. It says sealing was done and handed over to Arrow, and it was with wooden box seal number. Seal numbers are given.
Yes.
So not only the samples are sealed samples are kept in a wooden box and again sealed.
Yes.
So you have damaged that. Once the seal is tampered with, we can't allow your repetition.
Yeah, if more than one sample is needed, his nozzles and all the tanks were seized on that particular date itself. So if more samples were needed, they can extract from the tank itself, your lordship, because on that particular day, his all the tanks and the nozzles were also been seized, your lordship. Seized and
I don't know, I won't name something, but my personal experience of driving a car is that there are certain petrol pumps in the certain petrol pumps available throughout the country, from where if you fill up petrol, your car starts giving problem.
This is one of us, one of them, my lord.
No, I don't know. I'm not naming anything, but yes, there are some petrol pumps where if you fill up your vehicle, if you maintain your vehicle well, and you fill up petrol from some of the stations, you will find difficulties. I think all present here has vehicle. I think you all share the same experience. Mr. Datta, there are some petrol pumps you don't visit. There are some petrol pumps you don't visit.
Yes.
You want to avoid it.
Normally,
You visit only on compulsion.
yes.
I am issuing notice, but I don't find merit in the matter.
then your lordship, further processing may be stayed unless it will be infractions, because once one decision has been taken, retest cannot be done.
No, it will make subjective.
The last process is the termination. Once
Make
terminated,
it subjective. Whatever they do will be subject to outcome of the repetition. Mr. U. Sekiel and counsel for the petitioner, and Mr. S. Bhattakur Leonard, counsel for the respondent numbers,
1 and 2, my lord.
for the respondents. Next panel. The respondent authorities tested the motor spirit within bracket MS at the retail outlet of the petitioner and found a sample failing to meet the requirements of motor gasoline, GASOLINE, BS6, Roman 6, within bracket E10 bracket closed, with respect of density at 5 degree centigrade test and after reporting was done on 22/1/2023, the sales were suspended. The petitioner was served with the show cause notice dated 11/3/2023. And the petitioner requested for a retesting of the sample. The request for retesting of the sample was rejected by the respondent authorities by letter dated 2/6/2023. And they said communication is under challenge in the present petition under Article 226 of the Constitution of India. along with the along with suspension order dated 11/3/2023. This is 11/20 and students are challenging the application. If you notice a motion returnable in. We make it immediately after vacation. On 17/7/2023. Requisite extra copies of the requisition be served on the departmental council in course of the day. Next. The learned counsel for the petitioner has read for an interim relief on the ground that once pay for retesting is issued, the only consequences would be to terminate the retail outlet of the petitioner. Opposing the prayer, the learned counsel for the petitioner has, respondents has referred to where is that?
Page
Page
20,
40, your lordship, 2.5I,
Page 40.
40.
No, not that.
page 20, madam, last part.
Let's refer to it. Field report dated 22/1/2023. Deposit that the RO samples were drawn as per the what is MDG?
By the
Marketing disciplinary guidelines.
page 13, madam,
Marketing
discipline guidelines.
discipline guidelines and handed over to the retail outlet dealer for lab testing with seal by providing seal numbers. And it is projected that the said seals have been tampered with by the petitioner and one of such samples was tested by him, tested by the petitioner at his own risk. So accordingly, it is submitted that as the seals have been tampered, as per the respondents, the samples are not fit to be retested again. Next paragraph. Considering the nature of grievance of the petitioner, the court is inclined to provide that any action taken by the respondents in connection with the retail outlet of the petition shall be subject to further orders that may be passed in the red petition. Next paragraph. The Lawrence Standing Council for the respondents shall transmit the order of this court to the respondent authorities to bring the order to the notice of the said authorities. This terms and so.
We can proceed further, my lord.
Yes, I said whatever you do is subject to outcome, the orders that will be passed in the next date. 15. But you have to tell us what this submission which Mr. Sagi has made.
It is my page by the.
No. You see, there are
Comparing, my lord.
no, there are two samples.
Yes, madam.
Why another sample can't be used?
By page 40, my lord, there, my lord.
And your lordship, 2 samples were kept in the headquarters itself, territorial headquarters itself.
Page 40.
Yes, madam, there, madam, clause there, madam. Similarly, in case of a request from transporter for testing retained sample. That he just, madam, answer, madam.
Pardon
The
me,
same will, there, madam.
J.
Similarly, in case of a request from transporter for testing a retained sample, ma'am. This retained sample was answered, madam. The sample will be complied with by oil company. The sample of the transporter retained by transporter will be tested as per the guidelines by oil. Yes, ma'am, he has broken the seal, my lord.
Okay, if I understand this J correctly, you prepared two samples.
Yes, madam.
One is for the dealer and one is for the transporter.
Yes, madam.
A
Okay.
relevant provision would be H, your lordship. In
And
case
the
of
test
sample
result of the
failure.
sample will be compared with the.
Just H, what does it say? Please read that.
In case of sample failure and in the event of request from the dealer for testing his retained sample, such a request, if any, shall be made within 10 days of receipt of the lab test reported by the dealer. His sample along with the counter sample retained with the OMC are to be tested at PSU laboratory of his choice in the same nearby state of FTL Noida as per guidelines and in the presence of field officer and RO dealer. After due verification of the samples, the decisions of the competent authority, which should be based on the test result of all the three samples, should be decisive and binding on all. The expenditure incurred testing retention sample to be borne by the dealer.
So one sample is lost.
One sample is
So,
not,
so in any event, the three samples will not be there.
but in exceptional case, in I, it was said that in case of PL samples, if not present, then also only two samples can be compared. You understand? And in the subsequent provision, it was said that this test should be done before a decision is to be taken.
No, where does it say that two samples will be enough? Where is that? It doesn't say so. I doesn't say so.
But third sample is the sample taken from the lorry, this track.
Track, you understand.
As
In
well,
case
there is
that
no
sample
track,
cannot be
the
provided, then it's
Okay, then whatever is passed is there.
Yes.
obvious.
15. We have to issue a notice.
Yes, your lordship.
And why so much of contempt should not be drawn up against this authority? Why?
Lordship, the arrangement is same, your lordship, the entity. So lordship, what has happened? The mandate of the one-man committee was for 3 months, which was challenged earlier, your lordship, and stay was granted in writ petition number 925 of the 2022. So for the last 1 year, your lordship, the same person has been conducting as the one-man committee. So now only the officer has been changed, your lordship. The arrangement and the entity is the same, your lordship.
You can't do it.
Lordship.
You can't do it. It will be contempt.
Ideally, your lordship, prayer leave of this court should have been taken. I'll take instruction, your lordship, why this has happened, your lordship. Only one question I pose myself, your lordship, in case the officer is unable to attend duty for some reason, your lordship.
You take leave of the court. You see, there are not less than 2 posts of judicial officers all over the country where we can't, the High Court can't transfer the officer without the leave of the Supreme Court of India. Every time an officer who is a designated officer for that particular court, assuming that he is promoted, then also for relieving him, we have to file an IA before the Supreme Court of India and get a leave and then also do it. It's not just that
Lordship.
even if the High Court, who has independent power under Constitution to have control over its the judiciary within its jurisdiction, can't do it.
Lordship, will allow me to take instruction at this stage, your lordship. Why?
But Mr. B. Sinha, when counsel for the petitioner, and Mr.
V. Rajpal, your lordship.
V. Rajpal,
Corporation Department,
standing also for the Corporation Department. You're appealing for all the respondents?
all the rest.
The respondents. Next one. Despite order dated 11/2/2022, passed in WPC 9/5 of 2022. And order dated 1/4/2022, passed in WPC 2417 of 2022. It is projected that the no, as well as order dated 22/5/2023, passed in WPC 2417 of 2022. And connected IS Civil 899 of 2022, the respondent number 2, i.e. the Registrar of Cooperative Societies, by the review order dated 18/5/2023, appointed another one-man committee. Now, the said decision is assailed in the present writ petition filed under Article 226 of the Constitution of India. Next, issue notice of motion, returnable in 4 weeks. Requisite extra copies of the writ petition be served on the state and departmental council in course of the day. Next paragraph. As the next paragraph, the petition shall take steps within 2 days for service of notice on the. Oh no, there are no private responding. Okay, no, not required. Next paragraph. On both sides on the period for interim relief. As the impugn order was passed despite hearing before referred orders directing the parties to maintain status quo, court is inclined to stay the operation of, where is that order? Page
57.
stay the operation of the order under memo number JRCS/G1/97/part 2 PT footstop Roman 2/187, passed by the Zonal Joint Registrar of Cooperative Societies, Silchar Zone. Thereby appointing one Rayhan, RAYHAN, Ahmed Laskar for the management of and the whole AGM of the election of Bikrampur, BIKRAMPUR Cooperative Society Limited. Vice VIC, Vice Sri Zakir ZAKIR Hussain SUSSAIN. Shall remain stayed. No, this it will be petitioners number 1, and its order, last order is impugn order is not by 2, by 3. But Mr. Sinha,
Yes, ma'am.
what Mr. Rasko is saying, if you contest this matter, the one-man committee continues. How does it benefit you? Now the ARCS says that within 90 days you hold elections.
Yes, ma'am.
Now, if you contest this matter, this status quo is maintained.
Madam,
How do you benefit out of it?
the
we have to be, conduct the election if it is allowed, my lord, by this honorable court.
You will not be allowed.
Yeah, my lord.
You will not be allowed. What you call, whatever is there, the material on record is there.
Yes, my
I
lord.
don't think that can be allowed. Privacy, I'm not satisfied that you will be permitted to conduct the meeting. So one-man committee will continue. Doesn't help you anyway.
So, next time, my lord, I will try.
I don't find,
Because now, my lord, that earlier period also, my lord, there is status quo was there, my lord. Status quo as per earlier order.
but still there are reasons, I may not say it right now, but I don't find that you can be permitted. Privacy, but
Yes,
it's not a fan, but privacy.
And the other matter is fixed after 2 weeks, your lordship. It was fixed on 16th of this month, your lordship, after 2 weeks, where status quo was granted. In regard to the one-
List along with the other requisitions, so and so, so and so, and so and so. To 2 requisitions. Okay. Yes. Mr. Shah. Dr. Sarak, it will be same order as the earlier, Mr. Nayak.
Lordship, I have just one confusion, Lordship. Lordship, may kindly see the amendment, Lordship. Lordship, in this case, the clarification is under silence, Lordship. And if the clarification is interfered with, Lordship, then the provisions of the rule, Lordship, gets affected, Lordship. Lordship, may kindly see page 52, Lordship.
52.
This is the amendment of 7th of October 2021, Lordship. Clause 4, Lordship. Page 52, clause 4. Urban local bodies shall collect royalty as prescribed in the third schedule in 4 equal installments. The first installment shall be collected at the time of granting of building construction permission, Lordship. So this is very much part of the rule, Lordship. And the clarification is only a clarification
You
of
see,
this rule only,
collection of royalty,
Lordship.
can it be delegated? Here it says the urban local bodies can collect.
Lordship, for that, these
Statutory-
particular rules required to be silenced, Lordship.
No, no,
It's
third
only a
schedule of-
clarification, is only a clarification, Lordship.
The third schedule of CMC, you know,
Where?
third schedule at page 53. Appropriate
Yes.
amount of royalty to be deducted by the government agency. Now, this is only respect of supply under the construction within for the government. Now, the collecting may be that different agency, but in respect of the government agency only, private agency may not, it cannot be done. You also see the rule also amendment. The rule which has been amended. You also see page. I've reproduced, at page 13. At the bottom,
Yes, 13.
30. This is amended.
Anyone on rule two.
Yes.
Bottom, the minor minerals when shall be used or consumed by the government departments. So only when it is used or consumed by the government departments, the royalty is liable to be deducted. Now, the agency which can be collected, that is also in respect of the use and consumption of the government departments. Now, instead of the circular, which it says, we will also see the government department and the private agencies, entities. You'll also see page 57.
Just minor mineral concession rules, Assam. You have a copy of Assam minor minerals concession rules? Oh, it is available. It is available.
The challenge is only that when the rule says of the consumption by the government departments, whether consumption by the private entities can be brought in.
Just a minute.
Amendment is also. Amendment.
Oh, now I get it. Mr. Nayak, there is a probable answer for your query.
Lordship.
Now, this rule 5 is specially earmarked, what you call extraction site, which can be given deferred settlement to anyone else. It can be given for the purpose of the work of the government. That is a special rule. Otherwise, all other permit areas has to be auctioned and settled as per what you call tender. This is the only exception under Rule 5, where for any government work, you can directly settle it with the what you call any contractor. That is number 1. Therefore, there can be 2 interpretations. Number 1, if from this side, this is to you also, Dr. Saraf. You see, if you are allotted a mining area under Rule 5, then you can't give it to a private for private use. 100% it has to be used only for the purpose of government. And therefore, if you violate the conditions of extraction, then why what you call it, it can't be levied on you.
Submit, I'm not using it, look, I'm not taking it from mines, I'm purchasing from market. You know, I'm not extracting from the mines area.
Then 5 can't be applied. Then 5 can't be applied.
That's why, you know, the both.
5 is merely a mining right. You are giving it out of turn to someone.
I've stated in the petition, you know, in the petition itself.
So this you can't have it. You can get only from the.
This is amendment of Rule 3, Lordship.
Yes, yes, you have this.
Yes.
You also see para 4, I've stated, you know.
No, it's okay. Now I understand. When I read.
And our, in this petition, you know, the dispute is that this amendment which has been made is in respect of the consumption and use by the government departments. Now, on the basis of these rules, the clarification has been issued by government departments or private entities, which cannot be below apparently.
And the
That's why
5 you
the-
can't. You are right. You are right, Dr. Saab. Yes, in your hand is that 5. In
Yes,
your hand, yes, this is 5. This is 5, you'll find here.
Yes, Lord.
Correct. So 1, 2 is there.
And you also just see para 4, you know,
Para 4.
para 4 of the writ petition.
Because Mr. Nayak,
Lordship.
now what happens is that if I have understood this correctly, as some minor rules, then what happens is that person who is extracting, from there you can levy. But from the sale he is making, then you can't levy again. Royalty cannot be twice. Royalty is only in respect of mining.
No, it will not be twice, Lordship. Here it is mentioned that the royalties are collected by the urban local bodies, shall be deposited to the head of account of bank
So
account
who will do
and shall
the
be
extraction?
notified by the government, Lordship.
Who will do the extraction? You see, merely because a thela is going with a sand, you can't just stop him and ask for royalty.
I'm not extracting, neither I am good mines.
If he is not settling the mine, you
Lordship.
can't levy royalty on him.
And I've stated para 4, you know, clearly, you know.
There is no provision in this manner rules.
I construct my own building, purchase my chains, all these things from market. Now I am not liable to pay that royalty. Para 4, you know, I've stated specifically, you know.
You be ready with it, we'll take it after some time. Dr. Saraf will have to.
No, Lordship
And
will
the
issue
vendor
notice
must-
this stage, Lordship will what is the earlier, but that only question of maintainability will kept up in Lordship.
So when the similar.
Maintenance, we can decide it right now.
In that case, Lordship will take up this matter tomorrow, Lordship. Your Lordship.
But similar order has been passed and it says only.
It's okay, let him, because maintainability is being, if you have no objection on this issue of maintainability, we can go ahead.
Let
Or
him,
if
the
it-
maintainability will let him open, you know,
Okay.
I have
Okay,
no problem for that.
okay.
The maintainability issue can be
This-
raised anytime, you know.
Same order at 59. Only, Dr. Saraf will be there, assisted by Mr. Anand Datta for the petitioner. As well as Mr. P. Nayak, learned.
Lordship, I'm appearing for respondent number 7 only.
Then it's standing also for respondent number 7. You are appearing for 1 to 6 also?
No, Lordship.
1 to 6 will be appearing.
Mines and Minerals have their standing counsel. He is appearing for Forest Lordship.
You have for forest.
For the forest.
Mr. A. Barwa for the forest department. Respondent numbers
1, 2, 3.
1, 2, and 3. 4, 5, 6 will be
Lordship,
Mr.
Four,
Kirit Pathak.
four I am appearing, Lordship.
There is separate standing counsel for mines and minerals.
4 I can appear, Lordship.
Manson Mills, is it Mr. P. N. Goswami?
I
For
think
mines?
P. N. Goswami will go.
Huh?
Clean instruction.
I think P. N. Goswami.
P. N. Goswami.
Lordship, 4 I am appearing.
Okay.
Housing and urban.
4 and 7.
Yeah.
Mr. Nayak. Mr. Barwa for 1, 2, and 3. And Mr.
Well, it's mentioned at page 59, who has accepted.
Mr. K. N. Goswami, Learned Additional Advocate General. Appearing for respondent numbers.
1 to 6.
No, 5 and 6. Next paragraph. This page 59, same over.
Only page 60 below the last, but one paragraph. That will be changed, you know.
This, before this issue notice, keeping the issue of maintainability open, issue notice of motion, return in 4 weeks. Yes, what will be the change?
The last but one paragraph, the interim order pathways pertains only to the members of the petition association who are the.
Oh, acha. In the interim. This para will go.
Yeah.
And we said the interim order is would only be to the or limited to the petitioner in this case, in this petition. Second last paragraph. Okay,
Nice.
we can't stop benefit flowing to you. We can't stop benefit flowing to you.
It should be only to the petitioner.
That's what I said.
You'll also say that, this will be interim order, only respect the petitioner.
Only petitioner.
So the others will come,
That's what I'm saying. You can't prevent the what is the benefit to you. Board of Revenue. Board of Revenue.
No. So my Patta line was enforced by the forest department. I have purchased the Patta line, my lord, 10 bigha of land, my lord. Thereafter, in the year, my lord, 2006. Forest department claim it is a forest land, my lord. Ultimately, I
Oh,
have
acha. Yes, Mr. Barwa.
Notice may go in this matter, my lord.
But you won't disturb his possession. Mr. Barwa.
I don't really have to.
You can't disturb his position. You come to page 75. Page 75.
My lord.
Just before issue number 2. Therefore, I am of the view that plaintiff has a right title, interest, and position of this woodland, and this woodland is a Kherat Patta land. So with that finding, he will be entitled to an interim order. for Mr. P.S. Dekha, learned senior counsel, assisted by Mr. B.S. Dekha, counsel for the petitioners, and Mr. A. Barwar, and standing counsel for the Forest Department, appearing for all the respondents. Petitioners, plural, no? Yes. All the respondents, next paragraph. The case projected by the petitioners is that although there is a decree in favor of the petitioners in title suit number 113 of 2006, as decreed by Learned Civil Judge number 3, Kamru Metro Guwahati on 9/4/2012, the respondent authorities have forcibly cleared the land of the petitioner of all trees, etc., standing thereon. Most of the petitioners allege that the Forest Department is making an attempt to encroach and take over their land, purportedly on the premise that it is a forest land. Next paragraph. Accordingly, the action of the petitioners, the respondents have been challenged in the present writ petition filed in the Article 26 of the Constitution of India. Next paragraph. The issue notice of motion within 4 weeks. Requisite extra copies of the writ petition be served on the Department Council in course of the day. No, Mr. Dekha, why should we entertain your writ petition? Case 77. Case 77. Yes. Look at the order. Read that order.
In the result, the suit is decreed on contested form, declaring his right title and interest over the land. Position of the plaintiff over the land is also confirmed. The defendant, their employees, agents, workers are restrained from taking possession of the suit land and also disturbing the position of the plaintiff in respect to the suit land. Let the decree be done. It is the 2012 mail. Against that order, my lord,
It's a continuous rate. It's a injunction. You can enforce it in the the decree can be of injunction can be enforced in the civil court.
my lord, thereafter, they have, I am possessing you.
It's okay, but
Now, new cause of action arrangement.
it can't be.
They have
Decree, permanent decree will be always there. Even after 100 years, you can still put into execution.
Can, my lord, but at the relevant time, another cause will arise, my lord. They will again, my lord, they will.
No, it can't. See section 36 of the CPC.
But the authority is the government authority. my lord.
It's
They
okay.
cannot declare the,
You have a
another-
decree. You have a decree in your favor.
yes, my lord.
It's against the government. So why a writ petition?
Because, my lord, it is a confirmation of position, my lord, not recovery position. Earlier should be right declaration of right title interest and confirmation of position, not recovery position. So after the decree, my lord, I am continuing the position. my lord. The new cause of action arises.
Are restrained from taking possession. So if they violate this, it can be still executed. Why it cannot?
My lord, even if there is a decree, my lord, then also if government authority take some
No,
action,
they have been-
illegal
they-
action.
no,
That can be
no, in a-
under 26.
In a litigation, the government does not have a, what you call, a different, it's not different from a private person. Just see the CPC. Oh, you have this CPC? Okay. It's okay, he has it. You take a decision on the next day, we may close it.
For execution, my lord.
You have to do it because I'm issuing a notice right now, but you'll have to go for execution. Situation will not be maintainable.
My lord, because for declaratory decree or my lord, confirmation position, execution is not necessary. For recovery position, my lord, execution is
No,
necessary.
here it is restrained from taking possession. You are permanently restrained. It's a injunction.
Yes.
You take a call just because of vacation coming, I'm protecting you, but next day we may,
Till, my lord, till then, my lord. some
it's okay.
protection.
It will be
After
during,
vacation,
we are
matter-
protecting you. We should also motion determine for this, because the extra copies of the application decided on the Government State and Department of Council. Sorry, the Government Department of Council also did. Next, on the next date, the Government Senior Council for the petition shall address the court as to why, in view of the nature of decree passed in the suit, the decree cannot be put to execution. Next. As an interim measure, the court is inclined to provide that till the next date of this thing, the respondent authorities are restrained from taking over possession of the land of the petitioner, which is covered by the decree, judgment and decree dated 9/4/2012, passed by the learned civil judge number 3, Kamrup Metro, Guwahati, in TS number 113 of 2006. Next one. This order shall not come in the way of the respondent authorities to resume possession of any other land not covered by the decree, if the same is within the reserve forest area. Next, the petitioners shall produce a certified copy of this order before, accordingly, which will be starting. Yes, Mr. Verma, to whom?
My lord, the
DFO?
DFO, my
DFO.
Kamrup distribution,
DFO Kamrup,
East Division.
East Division, within bracket respondent number
Respondent number 3, my lord.
3. The next date, Mr. Dekai, yes, take a call of section 36. I'll take a break and come back.
Sorry, my lord, that I could not annex it, my lord. Well, there is a guideline of the National Handloom Development Program, my lord. My lord, internal page number 8, my lord. Internal page number 8, my lord.
Yes.
My lord, top, my lord, your lordship had find, my lord, lighting units, my lord. My lord, E, my lord. For empanelment of supply of each item, action shall be simultaneously initiated by the state directorate to invite bids through open tender. For tendering, the state directorate concerned shall follow the state guidelines and will constitute a tendering committee having representatives of the WS concerned as members. So we are the, my lord, empanel, my lord.
And if your lordship goes to this, goes to the tender notice also, my lord, there is a word, my lord, second line, my lord, third line. Tender notice at page 44, my lord.
Yes,
As per approval of the state level project committee meeting held on so and so,
you're reading where?
my lord, page
Ah,
44.
yes, okay.
My lord, yeah. As per approval of the state level project committee meeting held on so and so, the director of handloom and textile Assam on behalf of all implementing agencies shall invite bids into bid system, technical and financial through e-procurement system, my lord. Yes, e-procurement. Through e-procurement system, my lord. So there is a act, my lord. Well, this is an act, my lord, Assam Public Procurement Act 2017, my lord.
What is this lighting units? What do you mean by it?
So, my lord, lighting units, my lord, it's, my lord, financial assistance shall be provided for purchase of lighting units, including solar lighting system up to 15,000 per unit, my lord. Previous page, my lord, page 7. This is the scheme under, my lord, A.6.61, my lord, HSS, my lord. Hatkharga Sambardhana Sahayata, my lord.
And where is the bar that except for this panel suppliers,
My lord.
no procurement outside?
My lord, that I have just now provided, my lord, the Assam Public Procurement Act 2017, my lord.
Okay,
But
yes.
it's a big act, my lord. In lordship, may go to third page, my lord. My lord, clause 19, my lord.
Yes.
Registration of bidders, my lord, with a view to establish reliable source for a subject matter of the procurement or a class of procurement which may be commonly required across procuring entities or repeatedly required by a procuring entity. A procuring entity may maintain a panel of registered bidders, my lord. So we are registered bidders, my lord.
Yes, Mr. Dhar. You have to state then.
My lord. But the state is the implementing agency, my lord, handloom director.
My lord, I am appearing for the director who has called this tender, my lord. My lord, if you go by this tender, this is an e-tender, my lord, and let us, my lord, try to understand what you are trying to procure, my lord. These are, my lord, these equipments, my lord, will be distributing these to the marginalized, my lord, waivers free of cost. In Assamese, we call it hal when it is assembled together, my lord. This, those are the things, my lord. So, my lord, this tender is basically why we have come with this tender, my lord. This is for the best price that we can get. The cheaper, my lord, the low at low cost we get it, my lord. From a open bidding system, my lord, we will be able to procure more numbers of, my lord, equipments, so that we can reach to more number of people.
No, your idea is good. But is it in consonance with this Assam Public Procurement Act?
My lord, I will just before I go to that, my lord, I will just read two paragraphs from a judgment, my lord. What is the guidelines, my lord? My lord, I'm just passing over this book to my lord. What Supreme Court has laid down regarding, my lord, NIT principles. For my satisfaction, my lord is already aware of it, this Michigan rubber, my lord. 2012 8 SSC 216. I'm just reading from, my lord, para 23 and 24. This is the, my lord, guidelines for any public procurement, my lord, what is to be done. And if you are falling short of that, my lord, then my lord will obviously interfere, my lord. My lord, may I read from para 23, my lord? I have, my lord, that there is a book.
Just a moment.
Page.
Page para 23, 24.
Just a moment.
No, my lord. Okay,
Yes.
my lord. This I start from para 23, my lord. It is there, my lord. From the above decisions, the following principles emerges. The basic requirement of Article 14 is fairness in action by the state and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to the judicial review of to the extent that the state must act vividly and discretionary reasons and not whimsically or for any ulterior purpose. If any state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. Fixation of a value of tender is entirely within the purview of the executive, and the court hardly have any role to play in this process except to strike down such action of the executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms, such as the awarding of contracts by inviting tenders, in those circumstances, the interference by courts is very limited. In the matter of formulating conditions of a tender, document and awarding of contract, greater latitude is required to be considered to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of statutory powers. Interference by the court is not warranted. Certain preconditions or qualifications for tenders have to be laid down to ensure that the contractor have the capacity and the resources to successfully execute the work. If the state or its instrumentalities act reasonably, fairly, and in public interest in awarding the contract, here again interference by court is very restrictive. My lord, the following line, my lord. Since no person can claim fundamental right to carry on business with the government, nobody can, my lord, can claim a fundamental right that I have to do business with government. That is what my lord, Supreme Court has laid down, my lord.
It's okay.
Now, my lord,
According to you, what is the difference between a fundamental right and a statutory right? There is an act, Assam Public Procurement Act.
my lord,
It permits empaneled people to make this apply.
my lord,
You see, for example, I'll tell you simple, what I understand simply.
my lord,
You may explain it to me in a what you call difficult manner,
my lord,
but the simple things are
my lord,
for functioning of this court,
my lord,
I require these three items.
my lord,
You see, one is a pen,
my lord,
one is a pencil,
my lord,
one is a red and blue marker pencil.
my lord,
Correct.
my lord,
So if today evening I give a requisition to my court master
My lord.
to get me one of this pen or a pencil or a marker pencil, this red and blue.
My lord.
What he does it, he will go to the panel supplier and get me one, and tomorrow morning I have one pencil with me. Correct?
My lord.
For one pen, I don't float a tender. Correct?
My lord.
So there is a reason that what are always required forms a part of an panel supplier category, which is permissible in the what you call for procurement. That is number one. Number two,
My lord.
Mr. Datta has shown that
Yes.
this item, for this item, he has empaneled himself.
He has empaneled with, my lord, not with us. Not with us, not with Director Handloom and Textile. That is with, my lord, he has empaneled with Waiver Service Center, that is Government of India institution, my lord. There, earlier, if you go to page 26 of the writ petition, my lord, page 26, my lord, of the writ petition, there they have, my lord, have gone for a bidding. That was tender by Government of India. Page 26, Government of India on top, Minister of Textile, my lord. That was the tender, and these are the people who have participated, not us. This is not by Directorate, my lord, this tender from Government of India. This is by the state. They are empaneled not with us, with them. We haven't empaneled anybody as of now. Government of Assam in this procurement matter. If Government of India, my lord, again, this waiver center, they go for a tender, obviously. There, my lord, they will go. Empanel people will be called, but not us, my lord. And my lord, already 2 petitioners have participated in this tender, my lord. I have the list, 2 of the writ petitioners have already participated.
Just General, here, Mr.
Yes,
Datta.
next page, my lord, page 27. As because they have no empanel, my lord, suppliers, my lord, so they had called for a meeting, my lord. That is at page 27, my lord. I should have only annexed, my lord, the lordship will see attendance of the officers and empanel contractor of WSC in the meeting of supply of looms under block level cluster, my lord, under so held on 8 December 2020. If this minute is called for, my lord, everything will be clear, man. As because they don't have any empanel suppliers, man. That's why this meeting was called. They requested us to participate. To be there, man. The minutes of this meeting will, everything will be
You have to
clear.
tomorrow get this, this, what you call this, my minutes of 8 December 2022. If it has been called for and decision is taken, then the government is bound by it. Mr. N.J. Datta and counsel to the petitioner submits that.
My lord, these pertains to a different, this 8 December 22.
So whatever be, maybe it is different.
It's different, my lord. It is not a,
It's okay. Once Mr. Datta says that this is the decision taken,
Yes, sir.
you get us this.
Yes, sir.
It may be different, we'll not take cognizance of that. Sanjay Datta and counsel for the petitioner has referred to Annexure 3 to this petition. Project that for the purpose of supply of looms from a meeting was held between the authorities of Directorate of Handloom and Textiles, Assam.
No, my lord, here, I think, this. Respondent number 2 has to produce this.
Who is responding to?
WSC, my lord.
That is
no,
government of
no.
India, not us.
No, no. In
Yes,
the
ma'am.
conference hall of so and so.
Yes, my lord.
Conference hall of Directorate of Handlooms. Of the authorities of Directorate of Handloom and Textiles Assam and the contractors of
Suppliers of,
Weavers Service Center.
Yes.
On 8/12/2022. It is submitted that you said minutes are produced. It may support the. It may throw a light on the issue raised in the present petition. That's what according to the understanding was for the respondents.
three, he will be three, man.
For the respondent 3. Shall produce a copy of minutes dated 8/12/2023 within the annexure 3. Corresponding to annexure 3 to the petition. List on day after tomorrow. The motion column.
My lord, my direct also this central government, because if I don't get it there, then they'll have to bring it, my lord, from this.
CGC who's there? You're there? Mr. Adhar for the Handloom and Textile Department and Ms. As per what and CEC appearing for respondent number 1.
1 and 2 also.
1 and 2.
And CDC not appeared for Director Weaver Service Center. This is-
It's central government.
No, but this is under the handloom, what do you call it, Ministry of Handloom.
Yes, my lord.
I think you'll only be here. See this page
26.
26.
And then the textile.
Yes, that's it.
Is Government of India.
Well, I had a specific statement also, my
No,
lord.
no,
Paragraph
he does not know. You understand?
Yes.
Correct.
Yes.
1 and 2. This was the Illinois CEC also make an individual. So will be same. In this regard, the Illinois Council for the Petition shall provide extra copy of the petition to the Illinois CEC to enable her to open the minutes.
Can I pray, my lord, that an interim, my lord, not to open the price bid? The technical bid has already been opened, my lord.
When is the price bid going to be?
My
opened?
lord, I think, my lord, by today evening or by tomorrow, my lord. So that's by tomorrow, my lord, it's going to be.
My lord, nothing is going to be finalized, at least not in at least next 15 days, because it takes
No,
time.
no, not that. But
18, my lord, I had an interim prayer.
My lord can always, my lord, interfere in latter part.
no, after that, certain rights are created. That's why till the matter is taken up in the motion column on the next date of listing, comma, while the respondent authorities may go ahead with the tendering process, comma, but the
My lord may not, I will inform
Price-
them not to, my lord, go ahead, my lord.
no, you just don't declare the reserve price bidding.
Yes,
You can process the tender, and the price bid shall not be open till 24, sorry, till 28, 6/20/23.
My lord, we fixing out of 20.
26, this is,
28, my lord.
28, please 26.
I'm obliged, my lord, deeply
No,
obliged.
no, just a moment, just a moment.
No, my lord will fix it
No,
on Friday, my lord.
No, no, Friday, it will be 21st. I'm sorry, I missed out on dates. Friday, 23rd,
23rd, my lord,
23rd.
23rd.
Can I pray,
Deeply
my lord,
obliged.
if possible, Monday, my lord?
My lord, my
I
lord,
have
my lord.
some problem, my lord. 25. 26, my lord, sorry, 26, my lord. If possible, my lord.
25th
25th is.
or 26th.
26, my lord.
Yes, a difficult day.
I wanted this on 23rd only.
I have some problem, my lord.
First,
26.
Okay, 25th, 26th, okay.
I'm obliged, my lord, deeply obliged.
19. Yes, some difficulties can be helped. You take back your act, Mr. Datta. Yes, Mr. Goswami, we have to interfere here.
Yes.
Before the settling, he is collecting,
before opening the financial bid, my lord.
he is collecting,
No, no, sir.
you see
And I
page
think-
267,
Yes.
see page 267. You said best we can take it up at 2 o'clock, by then you can get instructions. If he's collecting this,
Lordship, Lordship, the technical bid was opened on 10/3/2023. I need to read it.
10,
10/3/2023.
yes.
My lord will kindly
yes.
come to my lord,
The, yes.
page number 45. End of the day, they have to follow the tender, my lord.
Yes.
Yes.
We-
Please
we-
come
we
to
have-
page 45, my lord.
Yes,
Opening and evaluation of financial bids, 3.2 ITB.
yes,
AIDC shall open the financial bid of the technically responsive bidders on the date and time to be informed in due course of time. When was it informed, my lord?
Yes, Lordship, all were informed, Lordship.
From শেষ কৰি ল'ব দিয়া, তাৰপিছত তোমাৰটো ক'বা। My lord will kindly come to my lord, page number 258, my lord. Sorry. 259. My lord, by this, post, my lord, the bidders were informed regarding, my lord, acceptance of the technical bid of the present petition. Please see, my lord, Wednesday, 17 May, 6:50 PM. Dear user, with reference to your bid submission, this is the number for tender so and so, your document has been accepted. Kindly see the 17 May. How on next day, my lord, they can, my lord, notify the rates at page 260. They have to follow the procedure, my lord. It is next day, 18. When was it notified? My lord, that's why in my lord, the International Airport Authority's case, Honorable Supreme Court said, my lord, the employer is equally bound to follow the rules. It's not that, my lord, a tenderer is only required to follow the rules. So it's something like putting the cart before the horse. Now, Lordship has rightly referred to page 267. They have started collecting money from third. It's a clear-cut case, my lord. And most importantly, my lord, his technical bid is defective, my lord, of the respondent number 7.
where is that?
Yes. My lord will kindly come to page number 41, my lord. Two point 10.2. My lord, we have definite information. One minister has called up. That's why, my lord, this order was passed.
Two point,
2.10.2. The bid document should be downloaded
and subsequently uploaded in the portal by signing in indelible blue ink by authorized signatory of the bidder. All alterations, omission, additions, or any amendment made to the bid shall be initiated by the person signing the bid. The idea is they must own up the responsibility by signing. Kindly come to their bid, my lord, at page 231. Because nowadays everything is available in the website, my lord. Page 231. That is the bid of respondent number 7, my lord. From 231 to 257. Not in a single page he has signed the bid, my lord. So this bid cannot be accepted.
No, if it's a e-bid, then
Yeah.
it will be digitally signed.
Yes. No, my lord. No, either digitally signed or, my lord, it must be signed and then uploaded. Now, kindly have a look at.
A digital signed document.
Yes.
uh,
No, even digital signature also does not appear, my lord. No, let us see, have a look at the language, my lord, at page 41. It does not speak of digital signature. The bid document should be downloaded and subsequently uploaded in the portal by signing in indelible blue ink by the authorized ex-signatory of the bidder. The idea is, my lord, the bidder must own up the responsibility. Tomorrow, if anything happens, there is a.
But this is contrary to e-bidding.
No, my lord, whatever it is, we'll go by the plain literal language of the tender document. It says you have to sign it. You have not signed it. This bid is liable to be rejected. Now, one more thing, my lord. My lord will kindly come to page number 272. Kindly see, my lord. In support of the bid, my lord,
Page?
this page 272. It's a income tax return acknowledgement of supposed to be of respondent number 7, page 272.
Yes.
Kindly see, my lord, after pen number name, Sipra Deka. Am I clear, my lord?
Yes.
Then please come to the next page. This is for another year. Name Brituras Deka, whereas Sobendranath Deka is the proprietor of respondent number 7. Well, how this tender has been accepted, my lord? A person who doesn't have any income tax file, he has been now. Supposedly, my lord, respondent number 7 is a proprietorship. So proprietorship and owner should be the one person. So, my lord, the income tax should have been of Sobendranath Deka, not of Sipra Deka and Brituras Deka.
Otherwise, if constitutional debate on 265 is not adopted. You remember that a man wearing a sari? You remember that?
No, I'm not very clear. I'm not aware of that.
In constitution
Assembly,
assembly debate
On Article
on
265.
Article 265, the I forgot the name of the very
That by authority of law. Any imposition of tax has to be by authority of law.
Their example is given of presumptive presumption. It says that what do you call? There is a man, and we presume that he is a woman, and there is a man presumed to be a woman wearing a sari. So on tax, that analogy is made that on presumption also certain item
Can be made.
which is not actually that for that purpose.
Physically
For
exists.
that purpose, no, not for that purpose. Say, for example, hair oil.
Huh.
For the purpose of taxation, it can be assumed that it is not a hair oil, it is a medicine.
Or
and
it
it
could
can be
be
taxed.
edible oil.
It could be edible oil.
It
So
happens, my lord. Coconut oil, it
coconut
happens. For South India, it is edible oil. For us, it is, my lord, hair oil.
oil. So same thing. For that presumption that in constitutional
Now I have
debates,
followed.
if a man presumed to be a woman wearing a sari, so that
So that
beautiful analogy is
265
made.
presumption will not come. Well, prima facie, my lord, this tender is not liable to be accepted. Secondly, my lord, how at page 267, they started collecting money, my lord?
No, that is the only thing which
Yes.
struck me. Where is the
No, my
order?
lord, even
Where
this
is
is
the
a-
order of settlement?
No settlement. We don't know. Till that it has not been disclosed. Now, kindly see, my lord, they upload on 17/5 regarding, my lord, technical evaluation.
Which
And-
page was that?
Yes,
Which page was that?
page, my lord, 1 second. Page number 259. Two 59, page are listed. 260. Page 259, my lord. Dear user, with reference to your bid submission for the tender, your shortfall document has been accepted. That is given to us, my lord. Please come to page number 16. At 268, my lord. Page 268. Kindly see, my lord.
Just a moment, where was that clause, signature in every page?
Yes, page 41.
Yes,
The
okay.
document should be downloaded
Yes,
and subsequently uploaded in the portal by signing in indelible bluing by authorized signatory of the bidder. This one, then my lord, the income tax papers are of not Somarendra Nath Deka, but of some two other person. That means you don't have any finance. And my lord, the authority is hell bent upon giving a work to a party whose tender is not even eligible. So his technical bid ought not to have been considered, my lord. There is no dispute that I am the second bidder, second highest bidder, and my lord, otherwise my bid is technically responsive. So there is no question of the authority giving the work to that respondent number 7, my lord. And this clause that they must notify the date, that they have not done. On 17th, they notify the technical qualification. On 18th, all of a sudden, how can they open the finance bid without any intimation? What was that earth-shattering urgency? Why have we put that clause in the tender?
answer is obvious. They want others to read it. Where is this discussion that?
So, my lord, nowadays, these things are happening too frequently, my lord. My lord, taking
Yes.
advantage of the constraint of a 226 code to go beyond certain level, my lord. Now authorities are taking advantage.
Mr.
Yes, yeah,
Goswami.
Lordship. Yeah.
Yes,
Technical beach, that NIT was issued on 3/01/2023.
P1,
30/01/2023. NIT was issued.
yes,
We received the beach. Technical beach open on 10/3/2023. Scrutinized on 25/4/2023. And after rectification, Lordship,
scrutinized on,
scrutinized on 25/4/2023. And after rectification, Lordship, it means some bidders, including the petitioner, Lordship, they have some simple rectification, Lordship, that we given them that extent, Lordship. And after rectification, Lordship, it was found that on 10/5/2023, the committee found 7 which correct, Lordship. This is the minutes, Lordship. Minutes dated 25/4/2023 and dated it's the minute it open it. In minutes dated 25/4/2023, it is specifically stated in page number 2, second page, Lordship, second page paragraphs 1 after the schedule, Lordship. We obtained 20 numbers of total bidders, Lordship, and thereafter, Lordship, the technical bids of the tenders were opened in the presence of the ARDC internal tender committee on 10/2/2023 at 4 p.m. Lordship got it.
You're reading where?
My notes dated 25/4/2023. Minutes
Oh,
of the
acha.
meeting, 25/4/2023.
Hmm.
Second page, Lordship. Second page, paragraphs, first one, Lordship, after the schedule, Lordship.
Yes,
The technical breach of the tenders were opened in the presence of the AADC Internal Tender Committee on 10/3/2023 at 4. Got it, Lordship? Yes, Lordship. And after that, Lordship, in paragraphs 3, Lordship, in the ITC held on 25/4/2023 at 3 p.m., Srimati R. Hajorika informed the following to the committee. So and so, these are the things, Lordship. And the thereafter recommendation, Lordship. And it after receipt of shortfalls documents online, 10/05/2023 at 5 p.m. It was finalized, Lordship. Total 7 bidders were found, Lordship. Technically were found technically correct, Lordship.
yes,
All these things were informed to the petitioner also, Lordship, because petitioner who rectified some shortfalls, Lordship. It is stated in the Rupam Chakraborty in last it is third page, Lordship. Out of the 9 bidders, so and so, only 3 bidders, Rupam Chakraborty, it is a petitioner, Lordship, and Mukhtar Ali and Sheikh Enterprises submitted their shortfall documents online, Lordship. It means they have ever with the fact that the technical breach were open, Lordship.
okay,
Yes. Now, Lordship, on 18/5/2023, these 7, those are technically fit, Lordship, technically found correct, Lordship. Their financial bids were open, Lordship, on 18/5/2023. My notes
just one.
dated 18/5/2023. Yes. Lordship, in and found that the respondent number 7 is the highest bidder.
Just a moment.
Yes.
You come back to your first minutes of 25-4.
Lordship.
You are reading page number 2,
25-4.
25-4.
25-4.
Yes, you were reading page 2.
Lordship.
Correct. The ITC held on 25-4 at 3 p.m.
Lordship.
Srimati R. Hazarika informed the following to the committee. Now there are 3 paragraphs here.
Yes, Lordship.
Now please, so far as private respondent is concerned,
Lordship.
in page 1, he is 6 of 20. Page 1,
Yes, Lordship.
correct?
Page.
Page 1,
Where?
page 1 of this same.
Yes.
He's serial number 6 of 20.
Yes.
Now in these 3 paragraphs at page 2, please find the 6 of 20, what documents he submitted.
Para 2. Page 2, Lordship, it is Roman 2.
Yes,
Yes, Roman 2.
1, 2 and 3, 3 paragraphs are there.
Yes, yes, Lordship. Second paragraph, Lordship. The bidders 8/20.
No, I have read it. You don't have to read it.
Okay.
Just find me documents of 6 of 20. No, take a seat. No, don't worry, twice I have read it, I have not, did not find it. You
Lordship,
see, I have put my pencil mark to make it easier for you. Since on the first reading I did not find it, I thought maybe I am making a mistake. So therefore, I try to underline 1, 2, 3, 4. So that I don't miss anything.
Lordship, these are the defect, these are the defect, Lordship, shown or shortcomings.
No,
Lordship.
no, no. They have to say what documents are found.
Lordship, but at these paragraphs, so far, after a perusal of this paragraph, Lordship, so far, my understanding is that the committee stated all regarding the defects and reason for rejection only. Those are the perfect.
No,
Lordship.
it's okay.
That was
You
not.
see, I'm only concerned, but what Mr. Chaudhary Senior Counsel has shown. You see, he has shown us two, what do you call, income tax returns. One in another name, the other in the another name. So therefore, they must arrive at a finding what documents were found.
Yeah, Lordship,
Merely by saying that all the documents are correct will not absolve the authorities.
But not only this one, Lordship, there are 7 persons, those have found correct, Lordship, including the petitioner, Lordship. Petitioner, regarding the shortfalls
It's
of the
okay.
petitioner is given here.
I'm issuing a
but-
notice, I'm issuing a notice and staying it.
So, Lordship,
Till day
it's
after
the-
tomorrow, you produce it.
No,
We
no,
give you 2 days time.
Lordship, one thing is that
Produce the documents.
so far regarding the stay of the letter of allotment is on 26/5/2023, Lordship. The after scrutiny, the allotment was given, a letter of allotment was given on 26/05/2023, and the lease agreement was executed on 31/05/2023, and property was handed over, Lordship. Handed over
It
on
has to be said.
3/6/2023.
It has to be stated. If the income tax documents are different,
But Lordship, this is so far the averments of the petitioner, Lordship. But at the same time, I have to take some opportunity.
at 2 o'clock.
Yes, no,
2
Lordship,
o'clock.
Lordship, the private respondent should be appear before the court.
No, no,
before,
no, it's not required.
big-
AIDC is the tendering authority.
Yes, Lordship.
They will have to show us that the income tax document which Mr. Chaudhary has produced is false. And
No, my lord, this is
No,
the
Lordship,
tender which
okay.
are downloaded.
no, it's okay.
Ah.
But what
So
has been
far-
downloaded is also available with you,
Yes.
correct? So you have to show that this downloading was improper.
My lord,
Tomorrow, Lordship, I will
Tomorrow,
produce.
okay.
Yes,
My lord,
tomorrow, Lordship.
Let me
I will
pose one,
produce on tomorrow.
let me point out one more thing. Supposing, my lord, I submit my tender without any signature as indicated in 3.2.
We'll produce it tomorrow.
No, my lord. The authority rejects my tender. Then I come to the court. Then what standard the court will adopt, my lord? Court will say you have not done it.
Correct.
So therefore his tender should be rejected on that count
No,
also.
we'll
On
produce
that
it
point,
tomorrow.
Lordship, I have
No,
the answer,
what we have-
Lordship.
What we have given is nowadays, my lord, in a
No,
e-tender.
I'm not disputing what, Mr.
Yes,
Chaudhary, whatever
yes,
you are saying, we are
ah.
not disputing it. But Mr. Goswami has
Yes,
a
Lordship.
point that he will produce it
Yes,
tomorrow.
yes, tomorrow itself, Lordship. Tomorrow.
I'm not
Tomorrow,
discounting.
my lord, if they put the signature and come, it
No,
will be
no,
very
no.
difficult, my lord.
No, because you have already
Downloaded.
downloaded it.
Yes.
Yes.
It will be available in your
Yes.
in your computer.
So my lord will kindly see, here is a case where on 18/6, apparently they upload the financial.
No,
Summary.
he has a point. I'll tell you what is there in that. Yeah. Although at this moment I'm not parting with it, and just I'll tell you what is it. The minutes produced discloses number 1, 30 January NIT was floated.
No, those dates, okay,
No,
29 for
no, I'll come
technical
to it.
bids open.
I'll come to it only if there are 6 dates. On 10/3 technical bids are open. 25/4 the scrutiny is done.
29 for they notify.
And on 10/5 they draw up a minutes of the final documents because they gave you an opportunity
Yes, yes.
before that. So therefore that is taken into account and minuted in 10 and it was accepted. This rectification which you did is accounted for on 17/5/2023 and on 18 they take a decision. So therefore I don't find fault with that. So the only
Oh,
only
my
thing
lord,
which-
where is the notification of date and time of opening of the financial
That has
bid?
already been opened.
Yes.
How can they without notifying?
No, that's what they are saying. You see, that is why
It's a
they gave you an
very-
opportunity of rectifying. That means on 24.
Lordship will kindly appreciate. If I am guilty, I should also be punished. If they are guilty, they should also be punished. What I am trying to say is, my lord, in a tender matter, it is not the discretion of the authority to allow, my lord, correction every time. Once, my lord, the last date is over, nothing can be done. If
No,
my
this is-
tender is
I'm
non-responsive,
not
reject my
finding-
tender.
Mr. Chaudhary, I'm not finding fault with it because of the reason that they notified it and opened it on 25 for 2023. Then in respect of 4 tenderers, it was rejected outright.
Yes. Out of,
And
yes,
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 and out of others, you and some others were given an opportunity of rectifying it.
yes.
And therefore this rectification came. Therefore, the tender is already open.
No, what I'm saying is, my lord, once the technical part is over, now it is open for opening of the financial bid.
Huh.
Then in terms of they are to notify, why they have not done that? That's what I've placed, my lord,
Already.
3.2. Well, look, these are all rules which are to be followed. These are rules not incorporated just to, my lord, violate it. Kindly have a look at page
No,
45, my
just
lord.
tell me, supposing you are technically disqualified, let us assume
Huh.
for the timing that you are technically
Yeah,
disqualified.
I'm end of the matter. I missed the bus.
Now, when the financial bids are opened, it will be notified only to those people who are there in the fray.
Yes.
Others may not be notified.
No, yes, no, well, in the portal, they will just put up a thing.
No.
That financial bid will be opened on, so that is how we get to
No,
know.
no,
They
through-
did not send us
Through
separate
email
letters.
and.
They did not send us letters. They did not do.
Through email and message, lordship, it was
Okay, so
informed.
produce
Yes.
that also.
Ah.
Yes,
If you have
lordship.
notified,
Yes.
produce that also.
Well, that will be very important in my
Yes.
humble.
No,
side.
it's okay.
Yes.
Accepting what you are saying. Mr. K. Chaudhary, Learned Senior Counsel. Assisted by Mr. Ellen Dingia, Learned Counsel for the petitioner. Mr. Next paragraph. The Learned Senior Counsel for the petitioner has pointed out that while downloading the tender of the private respondent number
7.
7, 3 major defects were found. Viz, we have read, number 1, that all the pages of tenders were not signed with blue indelible ink as provided under clause
2.10.2 of ITB.
2.10.2
10.2.
of the ITB and the income tax returns, 2 income tax return acknowledgements which were downloaded were in the name of different persons other than the bidder.
Bidder. In terms of, my lord, clause 36, Roman 13.
In terms of clause 36,
Roman 13.
Roman 30.
Within bracket,
XXX.
1, 3.
Oh, 1, 3, okay. Roman
36,
13.
13.
36, 13. Full stop. It is also submitted that the date of opening of the financial bid was not notified
In terms of clause 3.2 of the ITB.
in terms of clause 3.2 of the ITB. Full stop. Next paragraph. The learned, Mr. J.K. Goswami, learned, your standing counsel,
Yes, standing counsel.
learned standing counsel for the
One-
AIDC,
1, 2, 4, 1, 2 and
appearing for the fund numbers 1, 2, and 4.
1, 2 and 6, lordship.
1 to 6 has produced a photocopy of minutes dated 25/4/2023. Sorry, combined minutes of 25/4/2023 and 10/5/2023, as well as minutes dated 18/5/2023. Full stop. On a perusal of the same. No, sorry, there's only one more. You produce one more, 25/4.
25, 4, yes.
First, number 1 is 25/4/2023. Number 2, combined minutes of meeting dated 25/4/2023 and 10/5/2023. And number 3, minutes dated 18/5/2023. So on a perusal of the first minutes, the documents which were produced by the private respondent could not be identified. Mr. Accordingly, the learned standing counsel for the AIDC prays for his granted time to produce the relevant pending documents tomorrow in respect of the petitioner and the private respondent. Petition is not required, only private respondent. Private respondent. The learned standing counsel for the AIDC shall also inform the court about the manner in which opening of price bid was notified. Next, list in the motion column on tomorrow. Tomorrow in motion column.
Motion. call.
Lordship, Lordship and extra.
Oh, Mr. Chaudhary,
My lord.
you kindly give him an extra copy because
My-
otherwise he'll find it difficult
Yes,
to get
my-
all
my-
instructions.
At the same time, the order may be furnished.
Ah, yes,
My lord.
but you have to wait till end of the day.
Yes, Lordship. Lordship.
Let a copy of this order be provided to Mr. J.K. Goswami and standing counsel for the AIDC.